Today, we're talking about the Administrative Procedures Act. This is the act that came about as a result of the New Deal when President Roosevelt was enlarging government in the 1930s as a result of the Depression. And during that period of time, government grew to these large groups. It's even larger today, of course. And people were concerned about the amount of power that was starting to accrue to these various federal government agencies and departments. For example, the Social Security Administration, they administer Social Security, and they decide who qualifies for it, when they qualify for it, and they enforce all of these various rules. If you go to the Social Security Administration, they make some sort of judgment over whether you qualify for some Social Security benefits or not, and you disagree with that judgment, who do you have to go to get a review of it? Well, the Social Security Administration. So clearly people are starting to think, well, it's not quite fair if you can't go to an independent third party for review of these sorts of things. And then the fact that they're making all of these rules and regulations without giving the public a chance to see was very problematic. And this was a pretty significant act, the Administrative Procedures Act. There's quite a bit of debate back and forth over quite a large period of time before they finally came up with the Administrative Procedures Act that we have today. What we're focusing on in the Administrative Procedures Act is this rulemaking process, because if you recall from the last time I had the Federal Acquisition Regulations, which is a relatively thick book that is full of regulations and policy for federal procurement. Well, in order for something to get into that book that doesn't come directly from statutes or even from case law, which a lot of that stuff doesn't even make it into the book, it has to go through this rulemaking process. So the first step of the rulemaking process is someone has to determine that we need a rule. And then someone has to prepare the rule, and then it goes to the Office of Management and Budget for review. So if someone says, hey, I think we need a rule, and then hopefully some expert people go in to prepare this rule. This is always one of those areas that I find a little bit concerning because I don't know quite who prepares these rules. Usually it's experts. I mean, I'm certainly not saying they're not expert, but a lot of times by the time they reach this expert status and at this point in their career, they're fairly well removed from the actual day-to-day happenings of procurement, particularly in procurement because computers kind of happen to the federal government not too long ago. We were a little bit behind as far as like getting up to speed within the government, our government, on computers and electronics. So most of the people that live here don't quite know the electronic aspects of government. We'll talk a little bit more about that later. Then the Office of Management and Budget reviews, and then after they review, it gets published in the Federal Register. The Federal Register is published on every weekday, working day, and it is a register that is full of proposed rules, executive orders, various other things that need to be, the public needs to be notified of. Large reason for this, public comments. There's a minimum of a 60-day period so that the public can come in and say, hey, we really like that rule, or hey, we really dislike that rule, and here's why. A lot of times they won't write in to say this is a great rule because that's kind of a given that the rule is going to happen if they don't write in. So most of the public comments that come in are to point out areas where the rule has given certain interest groups or even individuals concern. Any individual can go in and make a comment on a proposed rule at any time. You just go in and follow the process for doing it. So then the rule closes for public comment. The people who wrote the rule get the public comments and then they gather them all together, lump them into similar concerns, and then they address the concerns, and many times they rewrite the final rule in a manner that will hopefully address all of the concerns that were raised in that public comment period. So the public comment period generally results in some concerns, and then between the closing of this and the final rule, they will go ahead and address that, and when they publish the final rule, they actually address in writing all of the main concerns of the public comment period. Then of course OMB reviews it again, and then it's finally published in the Federal Register. Sometimes it can jump back and forth in this public comment period and final rule for quite some time, depending on the complexity of the rule and how much concern there was in the first go-round. The OMB review at both phases, they're looking for some really specific things like the Regulatory Flexibility Act, Paperwork Reduction Act, plain language, various things that need to be looked for when making any of these rules. Other than that, they're not too long of a step in this process. This process can take approximately, it's usually about 18 months to 2 years. The government furnished property version took quite some time. When I very first was starting to learn about federal procurement, in the beginning class that I was in several years ago, was they said, oh, we're not even going to teach you about government property because it's going to be changing any day now. Well, the final government property rule, after going through this whole process, was issued approximately a year or two ago. So we're talking 13, 14 years essentially to go through this entire process for government property. Clearly that was uncommon, not a normal aspect of the rulemaking process. Otherwise, most rules, again, 18 months to 2 years. The Federal Acquisition Regulation rules are published at a site dedicated to the Federal Acquisition Regulation, so at any time you can actually go to that site, which I'll go ahead and type in that site as well as the Federal Register site, so you can go check it out for yourself. But you can go to that site and it will show you all the open rules for federal acquisition regulations and some of where they're at in this rulemaking process. So you can have a pretty good idea of the sorts of things that are being looked at right now. Also associated with this, and one of the critical things to know about the Administrative Procedures Act, is that the Act does in fact provide for a third-party review, and that third party is the Federal District Court. So an individual who feels like a final rule or something that's in the regulation, or an independent party, a non-government party like a contractor or a business, a nonprofit agency, individual, again, they can go to the Federal District Court and raise their concerns about rules and regulations that are in those federal acquisition regulations and any other regulations. So there is some sort of recourse provided for, which is actually really very nice for people to have that opportunity to say that maybe they feel like it wasn't fair or whatever the case may be. So the Administrative Procedures Act, fairly critical. That's how we get all of these regulations, and the fact it goes through this whole process is probably the argument that gives the fact that what's in the FAR should in fact have the full force and effect of law. It's not law, I mean it can be challenged, but it's gone through this process and it's in accordance with the Administrative Procedures Act, so there's a good chance that what's in there really should be followed. President Obama issued a memorandum last Wednesday where he was talking about the need for procurement reform, clearly dire need of it. That's why I started these videos. I need to step it up because I feel like we need to get a little more information out there before we head on too far down that road. But one of the things that he was suggesting is, well, not just suggesting, he was directing the people who prepare rules for the FAR, the director of OMB, and the Office of Personnel, a member from the Office of Personnel Management, to get together and publish a proposed rule by September 1st to make some changes that he was wanting to hone in on. The 4 areas he wants to hone in on, very much problem areas, and clearly we'll have some more discussion about those in the coming days. It will be fabulous. So that pretty much concludes the Administrative Procedures Act. Next time we'll talk a little bit about competition maybe, or I might get into the FAR, how it's set up and organized, and it will be really great. So until then, have a good evening.